routine investigations. Claimant was issued a query 1st July 2009, which he replied to on 15 July 2009, and consequently placed on interdiction, suspended later on 29 December 2009. Matter was reported to security agencies, upon which he was later prosecuted. I hope you got it up to that extent.
Yes, ma'am.
That was interruptions. Okay, let me just read it. The Upper Sharia Court, Gusau, Zamfara State, later discharged for want of diligent prosecution. Subsequently, SSDC of first defendant invited the claimant and two others, that is Financial Secretary and Treasurer of the SSA, to appear before it and responded to allegations of embezzlement of the funds in the SSA account. The report of SSDC is dated 21st April 2011. Another committee, which is the A and PC, also presided as Appointment and Promotion Committee, also presided over the same issue. And at the end, the two reports were submitted to the second defendant, which finally dismissed the claimant 22nd day of June 2011. Aggrieved by his dismissal, claimant went to Federal High Court and won. Defendants appealed to the Court of Appeal and lost. Then finally to Supreme Court, which set aside the decision of the two lower courts on the ground that the jurisdiction to try the action was vested in this court. Claimant now challenges his dismissal on the ground that he was not afforded fair hearing, was tried administratively for a criminal allegation instead of being charged before the conventional court, amongst other issues. So the issues for determination now, flowing from the issues submitted by parties, two issues have been distilled by court for determination thus: whether the instant action has constituted the statute bad, pursuant to Section 2A of Public Officers Protection Act. 2, whether defendants complied with the relevant laws and regulations in the proceedings leading to the dismissal of the claimant. The fact surrounding the contention of this objection is that claimant's cause of action arose 2nd June 2011 when he was dismissed, but the instant suit was filed 31st December 2021, contrary to requirements of Section 2A of COPA, which stipulates a period of 3 months for any aggrieved person to commence an action against a public officer. The defendant posited that this suit was filed more than 10 years and 5 months after the cause of action arose. He sought support in the case of Idachaba and University of Agriculture, Makudi. And for the claimant counsel, his contention against this issue is that defendants cannot seek the protection of POPA. Firstly, because as admitted by even the defendants, claimants had initially filed an action before the Federal High Court, Gusau, within the stipulated 3 months under the said law. Hence, the instant action cannot be said to be statute bad. Statute bad is a principle of law in line with provision of Section 2A, Public Officers Protection Act, simply imputes that where a legal action is commenced or initiated before a court of law, at the expiration of the period of time prescribed and limited by the statute, then the right that should have accrued in such action becomes extinguished by law. In addition, the rationale for this limitation is based on public policy that there should be no perpetual or unlimited threat of litigation, as it could result in disorder, anxiety, and agitation, which must be avoided. See Williams and Williams. Citations are provided here. Going further, a plea of statute bar challenges the jurisdiction of the court to hear and determine the suit, as it operates to take away the right of action and the cause of action itself, which is rendered barren because it can no longer be enforced. See also case of Oko and AG Ebonyi State. A very important point worthy of note is that prior to the instant action, there were court proceedings between the parties, which went up from the Federal High Court up to the Supreme Court, that rendered the decision bringing them before this court. The law is right that time spent at the wrong court ought not to be counted, because time was suspended from the time the suit was commenced at that court up to when it finally struck out. It was finally struck out by the Supreme Court. See Cyfax Nigeria Limited and MIGFO Nigeria Limited. Having already stated above that the parties are in agreement that the previous proceedings were filed within the stipulated time, defendants cannot claim the cover of POPA by counting the time used in the previous judicial proceedings, and I so hold. Now, the other leg of argument against the objection of statute bar canvassed by claimant's counsel is that claimant had alluded to the actions of defendants as done in bad faith and with malice. Hence, it comes under the exceptions to the applicability of POPA. Also is the argument that POPA does not apply in cases of labor issues and earned benefits. It is on record that the subject matter of the relationship and claims between the parties falls within employment and labor relations scope. Now, in the recent decision of Supreme Court in the case of Oluremi Obasanjo and another versus Wuro Boga Nigeria Limited and 3 others, appeal number SC 82/2010, delivered on Friday, 17 June 2022, the Supreme Court adopting its holding in the case of CIL Risk and Asset Management Limited and Ekiti State Government and another 2020 LPLR 49565 held that the Public Officers Protection Act does not apply to cases bordering on recovery of land, breach of contract or claims for work and labor done. The effect of the above is that this decision has taken actions and claims for labor and work done out of the scope of the application of the POPA, and I so hold. Hence, I find this action to have been properly brought, excuse me, and not cut off by the statutes of limitation. Issue 1 is therefore resolved in favor of the claimant. Now, issue 2. Under this issue, claimant asserted that he was not granted fair hearing. He alluded that his dismissal was contrary to Constitution, Federal Republic of Nigeria 1999 as amended, and all extant relevant laws regulating the relationship between the parties. The line of argument canvassed on behalf of the claimant, as contained at paragraph 24 of his witness statement on oath, is that he was dismissed by defendants on the basis of an allegation of crime without first being tried and convicted by a court of law vested with criminal jurisdiction, which can try and find him guilty. Against this position, defendants have argued that all they needed to do was to afford claimants an opportunity to be heard, which they claim to have done. It should be borne in mind that the parties hearing by virtue of the employer-employee relationship are regulated by the regulations governing the conditions of service of staff in the Federal College of Education Technical Gusau and the public service rules, among others. Before I proceed further, in the course of adoption of addresses, defendants' counsel had raised an observation as to the case of Olanrewaju and Afribank Nigerian PLC, 2021 8 WLR 75 at 86 lines 15 to 35, cited by the claimant that the said case is a 2001 case and thus not a recent position of the law as posted by claimant's counsel. I've had reason to make further research of my own and cannot but agree with defendant's counsel's submission that the said case in question is a 2001 case reported as Olanrewaju and Afribank Nigerian PLC, 2001 13 NWLR, part 731 at 691. Thus predates the Supreme Court case of Zide and Rivers State Civil Service Commission of 2007, LPLR 3544 SC, relied upon by defendants, and I so hold. It should thus be emphasized that counsel are to serve as ministers in the temple of justice by assisting the court to do justice and not to deliberately or even cunningly seek to mislead the court. I say so because the claimant's counsel never responded to the assertion as a mistake or anything of the like. Claimant's counsel is thus properly guided. In continuation of the resolution of the issue at hand, it is tried that in statutory employment, just as in private employment, an employer can dismiss in all cases of gross misconduct. In other words, it is erroneous thinking that once an employee commits acts of gross misconduct, which also discloses criminal offenses, the employer must wait for the outcome of a criminal prosecution of the employee before a court of competent jurisdiction, before proceeding to discipline him under the contract of service or employment. See Eze and Springbank PLC, 2011, 18 Nigerian Weekly Law Report, part 1278, 113, Supreme Court. Also in the PSR in Rule 030411, paragraph 030411 sub A, provides thus: nothing shall prevent disciplinary action being taken or continued against an officer, whether or not one, criminal proceedings have been instituted with respect to such a person in any court of law in Nigeria or elsewhere, or are about to be instituted or are contemplated, or two, the grounds upon which any criminal charge are based or are to be based are substantially the same as those upon which the disciplinary proceedings were or are to be instituted, unquote. The above provisions have settled the issue, and it is needless to state that the defendants herein did not contravene any law when they proceeded to take disciplinary action against the claimant without first making recourse to a court of law to institute a criminal action against him and get a conviction in that regard. Thus, that line of argument as canvassed by claimant is weak and fails and consequently discountenanced. Going further with regard to claimant's contention that he was not given fair hearing with regard to the allegations of embezzlement or gross misconduct as contained at paragraph 25 of his witness statement on oath and paragraph 8 of his additional witness statement on oath, I should state that the principle of fair hearing, which is as old as man and long legislated upon in section 36 of the Constitution, Federal Republic of Nigeria, 1999 as amended, in addition to several judicial pronouncements by our courts, is to the effect that a person who is alleged to have committed an offense or has an allegation against him shall be properly notified of the allegations against him, allowed to make a defense, tried timeously and by a competent body or authority, among others. More so that where an employment is governed by statutes and the procedure for employment and discipline is clearly spelled out in the relevant statutes, the employer must comply strictly with its provisions in dismissing its employee or terminating his employment. See the Supreme Court case of KS, JSC, and Tolani, 2019, 7 Nigerian Weekly Law Reports, at 1671 and 382. There is ample evidence before me showing that the claimant was issued with a query of 1st July 2009. He responded to same 15 July 2009, was invited by an internal memo dated 20th April 2011 to appear before the SSDC. He later appeared, made representations before SSDC of first defendant, which report is dated 21st April 2011, and the said documents were front-loaded by claimants upon, in his paragraph, as seen in paragraph 6 of his additional witness statement or note. From the foregoing, I find to be in compliance with the provisions of Rule 030-307 sub I, and find that claimant was not just notified of the offense culminating in his dismissal, but was also afforded the opportunity to defend himself, and I so hold. From the foregoing, I find the arguments of claimants in this regard to be baseless and hold that the defendants had fulfilled the requirement placed on them in that regard. In addition to the above, fair hearing is a procedure that does not just commence with informing the alleged offender of the allegations against him, but must also end with a verdict or judgment being handed down by an appropriate authority. The claimant counsel has argued vehemently that the dismissal of claimant was contrary to recommendations of SSDC, which is stated recommended for payment of his withheld entitlements. The principle has been established that where an employer gives a reason for the termination or dismissal of his employee's appointment, then he must prove same. See Oshisanya and Afribank Nigerian PLC, 2007, 6 NWLR, part 1031, 565, at 576 to 577, paragraphs H to A. Defendants had alleged and dismissed the claimant on the ground of gross misconduct flowing from embezzled funds of SSA of the first defendant. The entire gamut of depositions and documentary evidence placed before this court revealed that there was an allegation on the embezzlement of funds to the SSA of the first defendant, upon which claimant was issued a query, had replied to same, and even appeared before the SSDC in that regard. What needs to be asked is whether the said offense was established against the claimant by the various reports of the committees giving rise to the decision taken by the second defendant, as contained in the dismissal letter of 22nd June 2021. Excuse me. Okay, they are still online. I've taken, Counsel, are you with me?
Yes, my lord.
All right, thank you. I've taken time to peruse carefully through the reports of the SSDC dated 21st April 2011 and observe the following. A, The other two accused persons made statements incriminating the claimant without any documentary evidence that he shared in the illegally withdrawn funds. B. Claimant vehemently denied sharing from the embezzled funds with others. C. Claimant had agreed that on the date the SSA account was to go red, he made a deposit of 25,000 naira only on the claim that one of the accused, Lawali, sent him to deposit the amount to rescue the account from getting red. See page 13, finding 2, and equally page 14, recommendation 2 of SSDC report and the bank statement of SSA account with specific reference to the transaction of 17 December 2008. D. Also that pursuant to the above, claimant as auditor of SSA was aware of the state of affairs of the account at the time and did not raise an alarm or bring the facts to the knowledge of the SSA. Thus, the committee viewed it as an act of conspiracy amongst the three parties involved. See page 13, finding 6, and page 14, recommendation 2. E. That recommendation 3, which sought the lifting of claimant's interdiction and suspension order, was made on compassionate grounds, and the fact that the case had lingered for over 2 years, and not because of a finding of complete innocence on the part of claimant as alluded. F. Consequent upon paragraph E above, and the fact that claimant had sworn in the name of God that he did not share in the embezzled funds, and in the absence of documentary evidence, it was recommended that he be paid his entitlement. Now, the A and P committee of the first defender also met on 21st June 2011, apparently to review or consider the report of the SSDC as contained at page 1 thereof, and found that paragraph G, that there was conspiracy to defraud the college amongst the three parties, claimants inclusive, and concluded that they had committed an offense under the condition of service 6.64, 0.65, and 6.8, sub C. Consequently, it prayed that paragraph 6 of the report for the claimant's dismissal. Claimant counsel has, on behalf of claimant, challenged the appointments and promotion committee reports on the basis that it has no powers to entertain matters of discipline. I have observed that no rule or regulation was given to support claimant counsel line of submission to determine the scope of their powers. It is in view of that I jettison that line of submission. Another point that needs to be settled is the claimant's contention that A and P committee substituted the findings of SSDC for its own, particularly with reference to finding of conspiracy amongst the three parties. I have again painstakingly looked at SSDC reports, which the claimant relies on strongly, and particularly page 13, paragraph 6 of the findings, which reads thus, I quote, all the three staff, Abdullahi, Lawali, and Umar, knew that there was problem with the SSA Sterling bank account Buso, but none of them alerted the union members or the college. The committee sees this act as an act of conspiracy, unquote. Also, recommendation 2 of the same reports earlier referred to recognized that there was a conspiracy amongst the three. It is thus appalling to me that claimant is now querying the findings and recommendation of the Appointments and Promotion Committee, which to my mind only went further to apply the law as he deemed it fit, given the entire circumstances of the case. More so, look at regulation 6.8c, pursuant to which claimant was dismissed, falls within the ambit of offenses for which, if a staff is found in breach thereof, the punishment is dismissal. Thus, the argument of claimant counsel that the second defendant failed to follow the recommendation in the report of SSDC is untenable, as such reports and their recommendations serve as a referral point for the final authority, in this case the second defendant, to choose what line of punishment to meet, so long as it is within the scope of the law. It should be borne in mind that the reports and recommendations of committees are not binding on the management of organizations, but serve as a referral point. It is on the heels of the foregoing, I find that defendants did indeed prove by credible evidence that claimant did conspire with the two other parties to defraud the first defendant, who had stood as guarantor to the loan facility granted SSA. Consequently, it is my further finding that the dismissal of the claimant was done in accordance with the relevant laws. Issue 2 is thus resolved in favor of the defendants, and I so hold. The case of the claimant is accordingly dismissed for lacking in merit. Judgment is hereby entered.
Thank you, my lord.
Thank you,
More
Councillor.
chocolate.
So that is all for Sokoto.
Yes, my
All
lord.
right. You can now exit. Idado, thank you.
That's good.
Thank you.
God.